Malat, Malat, we are going to mention one matter, Malat. It's with regard to Order 41 event, Malat. Malat. Yes, Malat. Malat have, from today, Malat, till 5th August, my lord had determination.
Yes.
Yes,
Lordship may be permitted to mention an appeal which was been in connection with this Science City, which has been built 30 years ago.
Sorry?
30 years back, it has already been constructed. Science City, Your Lordship.
Yes.
Yes, my lord. That matter is still required to be included in the list. Earlier, it was being referred for mediation, but it was not succeeded, Your Lordship.
Give it.
Lordship, may I be permitted to mention? Lordship, may I be permitted to mention two appellate side matters? I am being led by Mr. Pratik Mujumdar. He is appearing online, Lordship.
Tell us. What do you want?
Lordship, in one of the matters, Lordship, I am being aggrieved by an appeal which was prepared by the bank in the year.
You want inclusion?
Lordship, this matter pertains to the list of urgent determination.
What is urgent about it?
Lordship, the appeal has been prepared in the year 2024. Till date, no appeal papers have been served upon. I am suffering. Lordship, on the last two occasions, the matter was taken up by the Honorable Division Bench, presided over by Justice Mantha.
Very well, sir.
I am only praying that the matter be listed and there be a direction that the appeal papers be served upon me, Lordship.
No, there's no urgency. Chalo, Daku.
Lord, the FPF for the appellant petition number is an affidavit of service, my lord. Served on all now. It's an application for condonation of delay, my lord.
No.
22 days.
Mr. Bordon,
My lord.
are you aware there's a request from the bar? What request? Unless all parties are present, not to take up matter?
I guess all are present, my lord.
All are present?
I guess.
2.
For the respondent number 1.
1, 4, 2. What about 3?
3. Sonali Bank.
It is your resolution, your request.
Understand. I thought I was adequately.
Why should we invite controversy?
Certainly not. Why should I invite my lords to invite controversy?
But isn't there such a request? There is. What to do? We can condone the delay, but
I want to file an affidavit. There was a miscalculation. The calculation is not correct. So why?
How much delay?
22 days.
22 days you will oppose.
There is a miscalculation.
So according to you, how much?
51 days.
51 days.
Yes.
We are condoning 551 days every day.
Give us opportunity. Just only give me 3 days time. I will file affidavit.
Fine.
I can't stand in the way.
Esho. Affidavit of service filed in court today be kept with the records. Stop. It appears that all the respondents have been served. Paragraph. Learned advocate appearing for respondent number 1.
Plaintiff respondent number 1.
Oblique plaintiff requests for a little time to file opposition to the application for condonation of delay. Stop. As requested, that such affidavit be filed within by Thursday. Thursday date ta diye debe. Stop. Reply thereto if any be filed by Monday date ta diye debe. Paragraph lists the matter once again on Monday itself or Tuesday week. Tarikh ta diye.
The affidavit of service be kept on record.
We have taken it already.
Notice the motion, sir. Notice the motion. Notice the motion, sir. I'm so grateful. Grateful. Number 2.
Cholo.
The matter I started and Lord, you had kept it today and tomorrow to finish it up because this is that section 9 family settlement March 13 and October 13 two family settlement. The other side is here. I saw him outside, Mr. Anuj Singh. You were sitting outside. Hey, in their presence, I know, but the letter, I would
Pass over.
let it pass. I will just get Anuj Singh. He's here. Let me pass. Item number 4. Item number 5 and 6.
My lord, in item number 8, I'm seeking a short accommodation for not today, my lord.
Cholo.
Number 9.
Lord, item number 9, I appear for the respondent. This is arising out of my section 34.
Your lordship, I'm appearing on behalf of the appellant for item number 10 and 11 for the respondent. I'm led by Mr. Jishnu Shah, the designated senior advocate, so humbly praying for a short passover.
12 and 13.
12 and 13, Lord, I am for the appellant, my lord. My lord, in this matter, my lord, we have filed the paper book, my lord, but we have found that some of the documents are illegible, quite illegible. And since it's a change brief, my lord, I have also talked to my other side. He also couldn't help on that because his copies are also illegible. It pertains to a long back, my lord. Therefore, my lord, would your lordship be kind enough to call for the section 34 records whenever the matter is taken up in the next week or thereafter, my lord? And then we shall also take an inspection and if something supplementary can be filed.
Learned advocate for the appellant says that although the appellant has filed paper books, comma, some of the documents included in such paper books, included in such paper book are illegible. Stop. As requested by him, comma, let the records of the section 34 application be produced before us on the next date. Paragraph. List this matter once again on Friday date either.
And if your lordship required, you can file a supplementary also after taking an inspection.
Chalo, কিছু লিখতে হবে না.
Would it be pleasure to take it in the next week, Lord?
Monday.
Instead of Friday.
Monday, next Monday.
Briefly operation.
Not today. No dismissal today, Mr. Sinha.
The only assured place I know, that's why we have come today. Today, the turnout is 1/3, 1/4.
Yes. You conclude today.
Yeah, of course. No. Do I need to rewind briefly the facts? No. I'll hand up the list of dates.
এই দেখো নোট করছিলাম কিছু.
আজকে দিয়ে দাও. Very quickly, I'll run through the list of dates. March 13 is the first MOU. And October 13 is the second MOU.
Yes.
Serial number 2 is between. And Lordship, the other relevant factor is July 13 is the MOU period. So my second list of dates is by July 13 what has been performed. 6 of the personal guarantees out of 14 had been released before July 13. Now, serial number 4 is 4 and 5 are between July 13 and October 13. between 4 and 5 are between July 13 and October 13 are the 4, 5 and 6. What is the performance? One is a corporate guarantee. Now, what has happened in between July and October is the respondents pledged 5 lakh of the shares, of these shares with central bank. Then, my lord, October 13 is another MOU that is in respect of 17 lakh shares of the MBL alone. While the first MOU is for 17 lakh, is for 55 lakh shares of MBL, for respondent number 3 being transferred, lock, stock, barrel, and several other components. All of them resigning from the board, then
Relinquishing all rights.
relinquish, yes, all sister concerns, associate concerns. That is the comprehensive MOU. Now, serial number 7 is the October MOU. Well, I wanted to just pause here for a moment. Well, the serial number 2, that is the release of the 6 personal guarantees given by them for MBL loans, could not have been pursuant to October MOU, because that happened between March and July 2013. So I'm thinking of what will be their case. Their case is, as they have so far argued, is that October 13 supersedes the March 13 MOU. There is only one MOU subsisting. So that, and the MOU was given a complete go-by to. But between March and July, 6 personal guarantees were released. So it is partly performed. Of course, it is possible after part performance even then to supersede. But this is one of the factors. Now, secondly, Lordship kindly comes to serial number 7 is the second MOU. Second MOU, Lordship, page 3, the underlined portion. Clause 2.1, 3.1, read with 3.2. This is the consideration clause. The MOU does not contemplate any clause for release of personal guarantees given by respondents and or their family members for the loans of ARP, which is there in the first MOU. Apart from number of shares being totally different, nor there is any clause for transfer of shares by execution of gift deeds. That's been a major form of transfer. This is a major distinctive feature between MOU of October and March. There is also no clause with respect to substitution of the MOU of March 13 by October 13. Other relevant clauses are validity period. Then there is no arbitration agreement signed by 6 of the parties out of the 5 out of the 7 parties. Out of the 7 parties to the first MOU, 2 only signed and were parties to go to the second MOU. And there's also no provision for them to resign from the board of directors of MBL and other group companies. Now, my serial number 8 is between November 15 and November 13 and January 15, where there is a correspondence regarding performance of the October MOU. That is serial number 8, page 4. In these correspondence, it is clear that respondent number 3, Prabhu, is unable to get the 5 lakh shares depledged, which is a term of the October 13 MOU. They are unable to get it depledged, so they want to perform the agreement in a different manner. Now, between serial number 9 is between December and June 14, 6 more personal guarantees are removed. What rupees? Rupees 392 crore. Well, here the money, the amount has gone out by mistake. আগেটা তো amount তো বেরিয়ে গেল কেন amount গুলো
crores of rupees.
yes rupees rupees 390 crores is serial number 9 ঠিক বলেছো আর আগেরটাতে serial number 2 তে কত crore
এটা আপনার 410 crores.
number 9
Yes.
number 9 is 410 crores while serial number 2 is
392.50 crores.
6 personal guarantees worth rupees
392.50 crores.
392.50 crores. Now, my lord, serial number 10. Serial number 10, my lord, may I pause here for a moment? May I just place this serial number 10, page 4. In terms of clause 1.2 of the MOU, parties to group 1, late Ram Gopal, respondent number 1, Aditya, respondent number 2 and 3, as also Shweta Maheshwari, wife of respondent number 1, had transferred altogether 38 lakh, 58,000 number of shares. Before October MOU, after October MOU, but all after July 13. Had transferred 38 lakh 58,632 number of shares of MBL to the petitioner and nominee for 24 crore as per particulars given below. Transfer by gift is 22 lakh shares. Transfer by respondent number 3, that's Prabhu, is 14 lakh 56,000 shares. And transfer by other members of the group 1 is 1 lakh 64. Transfer by, I mean by the, these are open market. Then note 1, pre-sale disclosures in form 10.5 were submitted at least 7 days before the actual transfer. So these are really pre-agreed transfer and not blind transfer in stock exchange. Not a single share of Prabhu transferred at 63.75. October 13 MOU, that's why. And then in serial number 11, Maruti resigned as director. There is no clause in the MOU for Maruti to resign as director.
Pursuant to March 17.
Then serial number 12, another two personal guarantees worth 37 crores released. Ram Gopal and Maruti. Now serial number 13 is suit number 54 being filed and interim order of injunction being granted in suit number 54. Serial number 14 is the several orders passed in the other suit and where they have strongly opposed, saying that the October MOU is a bad agreement, void, contrary to Securities Contract Regulation Act, unstamped, etc. Now 15 is April 2, 2015. By amendment, the October 13 MOU is extended till March 16. Then in July 15 is the 1:1 bonus shares were issued by MBL. That's another bone of contention because they said the bonus shares are not covered by the agreement. Though there's a specific clause in the MOU of March 13 that any bonus shares, dividends will all accrue to the benefit of for no further separate consideration. And Lordship, serial number 17 is really the starting point of the disputes. Before that, the suit was filed, but after that, the MOU was extended. Serial number 17 is when my elder brother had passed away. And for each of them, I've given the MBL share price prevailing as on that date. Just to give an idea, because they shall make submissions as to why when they were resisting, when they were proposing. Now, serial number 18 is 1st April 16, even the October MOU time expires after extension. Now, serial number 19 is when March 30, 2017, MBL goes into CIRP, Corporate Insolvency Resolution Process, is admitted to CIRP. Immediately, the share price drops to 46 rupees and then Then serial number 20, 3 several letters, April 1, April 14 and May 10, 2017. After MBL was admitted to CIRP, the price of MBL shares dropped as low as 12.50 per share. The respondent number 3 started issuing letters to MBL, whereby the said respondent number 3 called upon MBLA to buy 24 lakh shares, including the 12 lakh bonus shares. That is without honoring their obligation under the MOU of October 13, that is depledging, without honoring October 13 MOU of depledging the 10 lakh shares. Admitted that they are not in a position to depledge the 10 lakh shares. The shares were pledged for the loans availed by PI Minerals. By that time, the validity of the October 30, 2013 MOU as amended by April 2, MOU had already expired. PI Minerals is their sister concern for which they had pledged the shares, loans availed by PI Minerals. Then September 15, 2017, letter issued by respondent number 1 without referring to either the March 13 MOU or October 13 MOU to the petitioner requesting for release of personal guarantee given to Bank of Baroda for the dues of ARP. There is an express term in the MOU of March 13 for release of personal guarantee given by respondent number 1 for the loan of ARP only. That is only March 13 MOU has.
ARP is your company.
ARP is my company, MBL is, both are my companies. In MBL, they have 2.some% shares. In ARP, I do not know whether they have that 2-3% shares.
But in terms of this MOU, they had to also resign from there also.
There is the next such term is not there. So they expressly want release of the ARP personal guarantee that has to be under the October 13 MOU because the March 13 MOU, because the October 13 MOU is clearly only MBL guarantee will be released. But of course, this is their trump card is serial number 22. That is I admit that is the only weakness in my case. Otherwise that there may be a question of delay, but that is explained by serial number 22. The petitioner's reply for self and MBLA capital refusing to comply with the respondent number 1's request. Then I also say there is no such agreement. It is, however, a matter of record that the personal guarantee of respondent number 1 given to Bank of Baroda for the loans of ARP was subsequently released in April 21 by the petitioner through OTS, one-time settlement. The OTS amount was 8.50 crores, which amount in its entirety was borne by the petitioner. It's not that not the case of respondent that any of the respondents have made any contribution towards it. And on that day, the price of MBL shares was rupees 2.30 per share. That was the nadir, heart of CIRP. Then, yes, we disowned our full obligation. I will show judgment that cannot be a ground for refusing arbitration and for the arbitrator to decide what is the effect of that thing. That just because you have denied once the agreement, even though in their letter of September 17, they don't refer to any MOU. They simply say you have the guarantee released. I say I am under no obligation to release it. That's inconsistent with the March 13 MOU. My explanation
against what have you come up in
the order vacating the interim order of injunction, which was subsisting since June 2023. It was vacated in February 2025. There was a status quo on the remaining shares, which they were not willing to transfer.
So now they say they will not transfer because you have not performed your part of the understanding or arrangement.
Not indicating that if that argument was there, it would have been too easy for me because it's a matter of record that I have paid more than what shares have been transferred, have had all their personal guarantees released. They're not transferred. So they take a point that this March 13 MOU has been extinguished by the October 13 supersession, on which, of course, I want to judgment about closer. Judgment about closer. Ravi Kapoor, our country about closer. So that is their main point, and alternatively, my claim is barred by limitation. These are their 2 points. Now, serial number 2425.
Your injunction was on a section 9.
It was filed very belatedly. As in, if one goes by the date of the agreement, March 13th, and the section 9 filed in March 2023, 10 years later. But that is explained by disputes arising when? While the MOU which they are seeking to enforce now, October 13,
Oh, you have furnished a bank guarantee before the appeal court.
which now they want, that's out of pure brother dispute, these things happen. They want me to furnish and not being furnished by my company. Yeah, and they're writing the worst part, they're writing to my bankers and to SEBI. That's why I had to make the application that please vacate that part of the order pending hearing, because that's, after all, I'm a listed company, MBL. Now, now the dispute arising is really page 9 of my list of dates. I will just give, in August 2021, I discharge my part of the obligation fully. Serial number 25 in the list of dates. August 21, the ARP guarantee, which they were wanting me to get it released, they wrote in September 17, I got that released. And then in January 22, finally, my resolution plan, which was approved by the NCLT, was confirmed by Supreme Court. Till then, it was the appeal and they were, I mean, no, not they, there were banks, one of the other bank was the opposing, when I was appearing for that bank. Now, serial number 27 is when they first time write, not first time, my mistake, because September 17, they had written, notwithstanding the fact that the term of the October 13 MOU had already expired in March 16. The respondent number 3 called upon MBLA to purchase 34 lakh shares of MBL in 2 tranches without any readiness to depledge the 10 lakh shares. And that too at terms different from the MOU of October 13. This was only after the respondent number 1 got back his title deeds in August 21 in terms of the March 13 MOU.
5 years, no communication. 5 years.
For 5 years, there was no communication between 2017 and 2022 from their side. Because on now December 2022, we invoked the arbitration. I mean, the first stage of the arbitration, there is the amicable settlement. And serial 29 January, they refused to refer the matter to arbitration. And then comes March 2023 when we filed the application. No, sorry. And then they applied in the suit seeking purchase of shares shares by MPL, that we should perform our obligation. Theirs was extended till 16, and they filed after 7 years without filing any suit and application. And this we wanted to.
This is also not in terms of the October, because they had to.
This suit was filed by them in 2015.
By me. 2015 suit is filed by the petitioner in the Section 9 petition for the October 13 MOU to be performed. Where their contention was that the October 13 MOU is void contract. And this is what we had withdrawn in March 2023. Not me, my son's company, but MBL, my group, filed the suit. Now, page 11, serial number 36 onwards, 36 to 39, are the events which led to passing of the injunction order. Because post commencement of reference by 21 notice, they transfer certain shares for the first time. So we come and seek injunction order. So that is when Justice Bhattacharya, serial number 13, passed an order that you restore the position as on 6th of June, when you took time and adjournment on the ground that the affidavit was not ready. So whatever shares you were holding on 6th June 2023, you buy them back and you hold them. They have not done that, but at least they had not transferred any of the shares after the injunction order. So we filed another application in this Section 9 for implementing the order of 19th and 20th of June, saying that you have to buy back the shares and restore the position. Serial number 42 is a restitution application which they have filed in my suit, my disposed of suit. My argument there, it is a time-barred claim, dead claim. Court of law will not enforce it directly or indirectly. Plus, there may be very many grounds that is in the next court. It's fixed sometime in, I think, August.
It's running in the list.
It is in the list.
I've concluded.
Now, in serial number 43 is my Section 11 application, which was filed. And page 45 is the impugned order. And then comes the appeal court directions, and there's the new saga of their complaining to SEBI and banks that why did you allow a guarantee to be furnished to the registrar original site. Now, may I start now with this being the actual position? May I start now with the documents? This is the compilation of documents which they had wanted some more, which we did not include because we thought they wanted the Section 9, all the affidavits to be included in the compilation, which we thought will totally destroy the object of compilation if I have to include Section 9, J2, J3, affidavit. And so if they wanted to, let them rely upon it separately, and they're part of the paper book. So anyways, they are there. Now, Lordship, kindly, may I start with the copy, sir? Lordship, may I start with the impugned judgment? Lordship has read the judgment, so I will not place it. I will just show
Memo.
in the memo of appeal. To kindly come straight away on the October 13 MOU and March 13 MOU, their interplay. Or should kindly first seize paragraph 11.
Second paragraph is the very beginning of the
Paragraph 11, internal page 8 of the judgment. There are serious issues as to whether the MOU had been substituted or not. In view of the parties having entered into. Parties means everyone. Having entered into the subsequent MOU of October 13. First, where I would, with all the respect I can command, that parties are not the same in the second MOU. Lifting corporate veil, that's the arbitrator's domain. Prima facie, a reading of the MOU of October 30, 2013 would reflect that the original MOU stood altered. The correspondence exchanged between the parties also demonstrate that after a lapse of more than 10 years, that is on 26 December 22, did the petitioner attempt to revive the MOU. The question of whether the respondent number 3 is bound by the arbitration agreement also requires examination. In cases of family-run companies, although they can be treated as assets of a family capable of division, there cannot be a selective exercise. Admittedly, the respondent number 3 is neither a party nor a signatory of the MOU. This is where this Lordship will find this also at paragraph 2 of the impugned judgment at running page 28 of the memorandum of appeal. Paragraph 2. The third line of paragraph 2 at page 28, Lordship has held that admittedly the respondent number 3 is not a party ionomine to the MOU of March 13. And Lordship kindly knows October 13 from their side, only respondent number 3 is a party. Nobody else. Now, paragraph 11, admittedly, paragraph 11, page 35, admittedly, the respondent number 3 is neither a party nor a signatory to the MOU. Apart from this being factually wrong, this is an inconsistent case. The subsequent facts which have transpired after the cutoff date, that is 30th July, suggest the parties had, for all matters and purposes and intent, abandoned the MOU. But why? Lordship did not take a look at the fact that they had asked for ARP guarantee to be released. It was released August 21. Share transfers happened till 2014 September.
and by gifts also.
So July 13 cutoff date. By that time, even not a single share transfer had happened. Only 6 out of the 14 guarantees had been released before that date. Now, Lordship kindly comes to paragraph 13. There is no quarrel with the proposition laid down in Sanjeev Prakash versus Seema Kukureja. That's the Supreme Court judgment. The question of whether an agreement stands novated or not is ultimately within the domain of the arbitrator. Is ultimately within the domain of the arbitrator. However, at this stage, this is a question which requires a prima facie consideration in balancing the equities. The decision in Bharat Sanchar was noted is also misplaced, since in view of the glaring facts and circumstances, a prima facie view on the question of limitation can always be taken in adjudicating upon the question of interim leaves. Similarly, in the decision in Indian Oil Corporation is of no relevance, since the dispute between the parties are yet to be referred to arbitral tribunal. Because there it was held by the Supreme Court, Leadership Justice Indira Banerjee's judgment, that if an arbitrator, while passing an award arising out of one particular agreement, decides any dispute arising under another agreement, that award is bad. The case of Indian Oil Corporation dealership cancellation dispute, there was a separate agreement with Indian Oil Corporation for lease of the property, which provided for enhancement of lease rent periodically. The learned arbitrator, while deciding the dealership dispute, also said that the lease rent has to be increased or decreased or some. The Supreme Court held no. The award is bad because that was not referred to the arbitrator. So here, disputes arising whether October 13 MOU modifies the March 13 MOU may be a dispute incidental to March 13 MOU. But whether October 13 MOU has been performed or not, independent disputes arising out of October 13 MOU cannot be the subject matter, because what the arbitrator can't decide, the court also possibly, because after all, Section 9 is in aid of the final relief. So the court's power are wider, but then this is somewhat restricted by the arbitration. So October 13 MOU, whether it has been duly performed or whether we have correctly or incorrectly with filing a suit and withdrawing, that can't be. Now, Lordship, to start with, the learned judge's basic finding that respondent number 3 is not a party to the March 13 MOU is belied by the first disclosure in my convenience volume. Lordship sees page 1. Group 1 is Group 1. Kindly come to page 2. Serial number 5 is Prabhu International, respondent number 3. Then in the recital, it is specifically said, recital D, same page 2. Fifth party of Group 1 is the closely held company of the first party of Group 1. So the first party, 3 out of the 4 signed this agreement.
M is also there.
Ram Gopal, Maruti, and Anuj. No? Who all have signed it?
Ram Gopal, Maruti, and Aditya.
And Aditya. So, admittedly, Prabhu is a party, which is declared by the other respondents as a closely held company. Then recital M, page 3. The fifth party of Group 1 is the legal and beneficial owner of 31 lakh shares, each fully paid. So this is description of fifth party. So this is the crux of the learned single judge's judgment, is that no prima facie case, because I want injunction on respondent number 3's shares. And respondent number 3 is not a party to the agreement at all. So section 9, I will have no right. Now, this is the fifth party is serial number, recital M. Then
Yes, in the parties under Group 1 are collectively holding 55.
Yes, the Lordship, recital G is also important. Parties under Group 1 are collectively holding 55 lakh shares. So these 3 recitals followed by the first operative clause, where Prabhu's shareholding is given. The last of the names in Group 1, Prabhu International Private Limited, 31,60,290 shares. That's also mentioned. Then 1.6. 1.6. Since Prabhu is declared as a closely held company of other members, the parties of Group 1 shall transfer all their shareholding in Prabhu to parties of Group 2 and resign as directors upon. And finally, the Lordship kindly comes to the page 12. Sorry, page 10. Page 10. This is signed and
Mr. Mitra, one second.
না তোমার কাছে যাবো এটা আমার দিও নেবেন না তুমি লিখে দাও আর কাগজ দাও
কাকু কি? হ্যাঁ,
এটাকে তুমি থেকে আর এই থেকে ওর সঙ্গে রেখে
হ্যাঁ, নট টুডে। শোনো, সেকেন্ড কলেও না থাকলে নট টুডে হয়ে যাবে অটোমেটিক্যালি।
Second call, item number 5 and 6. 5 and 6 also I'm praying for not to.
Yes.
Second call, item number 7.
7 I appear for the appellant. I'm led by AG in this matter. Kindly fix a date 2 weeks hence. If he comes on the next day, he'll argue. Otherwise, I'll argue. Because I've been praying for adjournment.
On the request,
date and time if possible.
Time we can.
Very well. Any date may be fixed.
On the request made by Mr. Singh, learned counsel for the appellant, who says that he is led in this matter by learned Advocate General, let this matter stand adjourned, and you give us a date and be listed again on
6th of August.
August 6, 2027. উনি যে বুঝে এতদিনে জেনে গেছে। Not today. Not today.
10 and 11 are, my lord, I appear for the appellant in one of the matters, and my lord, there is a cross appeal, my lord, in the other matter. Now, my lord, what had happened is there was an arbitral award that was made.
Request from the bar.
Yes, yes, of course. Your name? Other side caste.
Not today. Not today. Did you face any difficulty reaching court?
No.
Neither did I.
I don't know whether we'll have some trouble going back.
Yes.
But coming here was not a problem at all.
Second call, item number 14.
I think it will be possible. Other side is
not today.
Sir, my learned friend's mother has a surgery on Wednesday. She was requesting if it could be on Thursday.
Thursday. তাহলে করে দাও Thursday. অর্ডার দিচ্ছি না, Thursday করে দাও।
Great. But the others, the bench changes, but my HITCO appeal will go.
Which bench is hearing the HITCO appeal?
Your lordships are hearing.
Let us see. We are not 100% certain whether the bench will break, whether determination will change.
We'll know by the end of
And
the day.
then you can always have it assigned before this bench.
Yes.
Like in some other cases, it has been done. বলো non-commercial. হ্যাঁ।
Commercial. Application item number 1.
My lord, I am for the plaintiff respondent.
What? Not today. The other side is not there, Mr. Agarwal. Unless all parties are present, we can't take up matters today. Okay, shall we pass it over? Pass.
Today also.
Not today.
Item number 2.
Not today.
Item number 3.
Pass over করো।
Item number 4.
My lord, in 4, my lord, I am for the respondent, my lord, 4 and 5.
Pass over.
Item number 3.
My lord, in this matter, I am for the appellant, my lord. We have concluded our submission. It was the respondent who was to ask.
Mr. Shobhoshachi Chaudhuri.
Mr. Chaudhary is my counsel. He has finished his arguments. Other side was to argue.
Not today, Mr. Agarwal. Today, nothing can be done.
Item number 8. Item number 9.
My lord, the respondent, the appellant was submitting, my lord, Mr. Dheeraj, learned senior counsel Dheeraj Trivedi was submitting on behalf of the appellant, my lord.
Pass over.
Item number 10. Item number 11. Item number 12. Item number 13 and 14.
Lordship, Mr. Sabyasachi Chaudhary is appearing for the respondents.
He has gone to England.
Yes, so he is not there for 2 weeks. So I was praying for if he.
You are for the
I am for the appellant.
So when?
So he-
August 4.
August 4 onwards.
August 4.
Keep your-
Item number 15. Item number 16. Item number 17. Item number 18.
18, I'm praying for a short call, passover, my lord.
Passover.
Item number 19.
Even in 19, my lord.
Passover. Second call.
Second call. Item number 3.
Today, এগুলো সব যেগুলো না হলে not today হয়ে যাবে।
For the official liquidator, your lordship.
Item number 4.
It's not 4 and 5, Lord. Just today nothing can be done.
কেউ তো নেই আর not today.
Item number 8.
Same.
Item number 9.
Nine was Mr. Trivedi. Yes. Not today.
Item number 10. Item number 11.
But I am appearing for the appellant. Lord, kindly make it not today. Lord, I could not reach the court. Kindly make it not today.
So unkindly not today.
My lord, I'm grateful, my lord. I'm grateful.
Item number 15. Item number 16.
It's not today.
My lord, item number 15, I was appearing virtually, my lord. Item number 15. And for the respondent, this arises out of an order which was passed allowing my order 12 rule 6.
I'm in item 16.
Oh, I see. Miss Ghosh, nobody is there for the appellant.
Oh, okay.
Chalo.
16.
Lordship, not today.
Kindly or unkindly?
Kindly.
Very well.
Grateful, Lordship.
Item number 17. Item number 18.
NTD.
19.
Lord, that will kindly unkindly in this matter, my lord, online, my lord.
My lord, I was also my lord addressing, but my lord, unfortunately, I'm so sorry, my lord, I am.
Absent to answer in 19.
19? What is 19?
My lord, 19, my lord, I was arguing, my lord, the order to rule 2 point, my lord, and the other issue. My
Oh,
lord.
yes. That who? Srirampur.
Sriram, correct.
Not today.
Very well.
Chalo, appellate side আছে কেউ?
Item number 13 and 14, my lord.
13 and 15 have been dismissed. Are you for the appellant? Respondent then allowed.
My name be recorded, my lord. Your lordship fixed on 4th, my lord.
Order pass.
Order হয়নি কোনো. No order has been recorded.
Your lordship fixed on 4th, my lord.
Yes, but no order has been recorded, Mr. Mondal.
Second call. Item number 1. Item number 2 is item number 3. Item number 6. Having said there is non-commercial matters. Item number 1. Number 2. 3. Second call, item number 1. Item number 2. Item number 3.
এই টিভিটা কেন এখানে আছে? লাগিয়ে কিছু না কাজ করলে
এর সাথে কানেক্টেড